Okay, good evening. It is November 18th, 2025, and this is the regular meeting of the Bonner County Planning and, City of Sandpoint Planning and Zoning Commission. And it's 5:30 there, so. And we are in the City Council chambers at 1123 West Lake Street, Sandpoint, Idaho. For the record, I am Commissioner Vice Chair Wayne Benner presiding. Also present are Commissioners Reed Weber, Ivan Remar, William Mitchell. Is Scott Toby on Zoom? Oh, hold on.
Do you have an extra pen over there?
We'll wait for a second here to see if.
Oh, thank you so much.
And William Mitchell's also here, but is Scott on Zoom by chance?
No, Commissioner. Mr. Torpy's not on Zoom.
Okay, thank you. Okay, so we do have a quorum of 4, so we will proceed. If everyone will please stand, we will recite the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, do commission members have any announcements or reports? Okay, we'll proceed to the consent calendar. We will now proceed with at this time, and I will entertain a motion to approve the consent calendar as presented.
Make a motion, we approve the consent calendar.
It's been moved. Second. All in favor, say aye.
Aye.
Okay, motion has passed. Okay, for matters from the public and general public comments, if you have or would like to speak on a topic pertinent to the city business that is not on the agenda, this is your opportunity to do so. If you wish to speak and haven't yet completed a sign-up form, please do so and hand it to staff. The forms are located on the table by the doors. If you are attending remotely and wish to speak on a matter that is not on the agenda, please raise your hand on Zoom at this time. I would like to make everyone aware that the city does have a policy on public meeting decorum. The rules are posted on the wall just outside the chamber entrance doors. In summary, I would ask that everyone please be pleasant and respectful, not make derogatory statements about others, including city staff, not be disorderly or disruptive, no calling out, clapping, or holding up signs, etc. Please note that the commission cannot take testimony on any specific planning and land use related matter or application outside of the official public hearing process. As there are public hearings on the agenda this evening, please hold testimony on those matters until after the hearing is open. This time is for general comments on topics not included on the agenda and for comments only. No questions or debate. You may contact the mayor or staff during regular business hours if you have any questions or concerns. When it is your turn to speak, please state your name and whether you reside in Sandpoint city limits. Each speaker will have up to 3 minutes. Madam Clerk, is anybody signed up to speak during the general public comment time, or are any hands on Zoom?
Nobody signed up to speak.
Okay. So everybody hears for our items on the agenda. Okay, we will proceed then with the public hearing. And the next is a public hearing to consider a conditional use permit PCUP 25-0002 Chosen Motors. I will now recite the order and procedure for the public hearing. Staff explanation of the subject of the public hearing, presentation by the applicant or their representative. Any questions should be directed to the applicant at that time. Opening of public hearing, at which time the public may provide testimony. Those who wish to testify are required to complete the sign-up sheet. If commissioners wish to ask questions of the person testifying, those questions need to be posed before the person returns to their seat. The order for those who wish to speak will be as follows: in favor, neutral, and opposed. Rebuttal testimony from the applicant or their representative, and then final questions may be asked of the applicant at that time. However, if new facts are brought up, the public will be given an opportunity to comment on any new facts. The public hearing will now be, and then the public hearing will be closed for deliberations. No new information may be provided after the hearing is closed, and any questions may be directed only to staff during deliberations. For the record, any written comments received were included in the meeting packet or otherwise provided to the commission if received in time to do so. Before we proceed, I will ask for confirmation from each commissioner that you have no conflict of interest or ex parte contact regarding this matter. Commission? No?
None.
Okay. Then we will proceed, and I will yield the floor to City Planner Bill Dean for an introduction of this application.
Thank you. Good evening, Chair. For the record, this is Bill Dean, City Planner. First of all, I'd like to thank Eric Brubaker, who's unable to attend this evening. Eric put a lot of time and effort working with the applicant, Craig Leone, to see that this gets before you. Jason's going to work through a slide deck. Essentially, this is a relatively routine matter. Our zoning ordinance establishes that certain land uses require Planning Commission approval of a conditional use permit prior to the commencing operations. And this is one of those cases. There's an existing business, a used car sales that's an existing Sandpoint business that would like to relocate down Highway 2. So the nature of tonight's hearing is to conduct a public hearing and try to arrive at a conclusion related to the findings that are in the staff report. Again, Eric Brubaker did a nice job of assembling the report. On page 6 of the staff report are the findings. But just by way of introduction of what this project is, we're talking about a used car lot that will be located in the commercial C zoning district. And that is a land use that's allowed. The way our zoning ordinance works is there's a map, and then there's a table within the ordinance establishes what types of uses can and cannot occur. A used car lot can occur upon an approval of a conditional use permit. So next slide, Jason. This is a location of relocating an existing business. We all may be familiar with seeing vehicles for sale on this particular intersection. So we're going to be relocating this down the street. Next slide. To this location, which is the 1213 Highway 2. We have a couple images here just to familiarize yourself with what this location looks like. There's been a number of businesses over the years at this location. And Mr. Leone has identified this as a spot that could accommodate his business and continue to provide this service to the community. What we're looking at with the conditional use permit is the basics in terms of how the site functions. This is a parcel you can see identified here as 1213 with a little green dot on it. There is ingress and egress along Highway 2. That's common along this part of the city. There's a ample opportunity for ingress and egress. Notably, with this particular type of land use, we're looking at a couple things. Number one, ingress and egress to the site. Number two, is there enough area for vehicle storage for the intended display area for the vehicles? In this case, there's a gravel area located just to the west of the building that is intended to be the place where the cars for sale are located, and there's customer parking in front. One of the conditions of approval that staff is suggesting should commission want to move forward with this is to add some landscaping along the front of the building, as identified in the staff report, to help be code compliant as it relates to the requirements for how we treat our parking lots in Sandpoint. Let's go to the next slide. So again, this is across these aerial images, you can get a sense of the various uses that have occurred here over the years. In this particular site, you can see the vehicle storage areas to the west of the building. The parking would be there on the north side. Let's go to the next slide. So really what the zone district is for is to accommodate lower intensity commercial activity that's a little bit farther away from the downtown core. And as you can see on this slide, that vehicle sales are permissible upon approval of a conditional use permit, and limited to 12 passenger vehicles for sale. The comprehensive plan also, in a broad way, speaks to the need in the community for, continued business operations, and the zoning is really the operating mechanism in our land use scheme here to allow these types of uses to locate. So it's consistent with the comprehensive plan, it's consistent with the zoning ordinance, and it meets the standards that are established in Sandpoint City Code Title 9. Let's go for the next slide. As with any application, when we receive this, we send it out for review. We were curious to see if the Idaho Transportation Department had any comments. They have no objection. The Independent Highway District also looked at it. It does not abut a city street, it abuts a state highway, so they didn't have any, objection to the project. And the EQ also didn't have any comments as well. So let's go on to the next slide. So there's a number of conditions of approval that are identified here. Again, working with a small business, we can defer a couple things that are identified here in the conditions of approval to prior to commencing the land use. Just want to make sure the site plan actually indeed reflects the fact that there's going to be some restriping of the parking, that the chain link fence that's there now, is the vinyl slats will be taken out, it'll be painted black to make it a little less visible. Future parking lot lighting is going to have to be code compliant with our dark sky ordinance, for example. So some of the typical things you'd see in conditions of approval are identified here in the conditions. And again, like the last bullet there, prior to commencing the land use, we want to make sure the site plan is just in the file showing at least a certain number of square feet, about 18 square feet or so of planting and landscaping is shown, toward the front end of the building. Next slide, please. So, again, this is a public hearing tonight, Chair, so you'll be taking some testimony. You'll hear from the applicant. And you have the opportunity to approve the application with the conditions or take other action. That is entirely up to the commission. The effective date of any action will be after we come back with a written decision following your decision this evening. So I think that may be the last slide. Let's see. Yeah, we'll leave it for questions. If you have any clarifying questions of me, Chair, be happy to answer those. And then otherwise, I'll turn it over to you to conduct the hearing and hear from the applicant.
Does any commissioner have any questions for staff?
I just had one question. So if there's that proposed landscaping, can you point out where staff was proposing that would go on the site plan?
Sure. If we pull the slides back up, we can pull the site plan up. First of all, let's look at the condition of approval to see how it's worded. So it's the slide preceding this one. Right here. It's the last one there. Prior to commencing land use, applicant shall submit an amended site plan showing at least 18 square feet of planting, landscaping, flower bed, to the satisfaction of the community planning and development director. So let's go to the site plan now and take a look of generally where that would be located would be typically you'd want to see something. I would imagine this is going to be somewhere close to the building. It could be located really anywhere on the site. I would suggest that this is going to be better furthering the objectives of the requirement if you have it in the front of the building somewhere. So I think there's an ability to put it anywhere along the front. As you get farther toward the northern property line along the highway, it gets a little more complicated because that is a fairly widely used tarmac of an area to come and go from these sites. So I would suggest we're just careful with where we might want to see that located. And that's why we're suggesting probably closer to the building. But hopefully that answers your question.
Commissioner?
Looks like space 3 and 4 are in the parcel to the east, the Ponder and Mechanical parcel. How's that working?
All the parking has to, the site plan, one of the conditions just reflects the fact that it has to be restriped to demonstrate that all the parking is actually on the site.
Okay.
So everything has to, there's no reciprocal easements and things like that with an adjacent property owner. It has to perform again on its own parcel, on its own lot.
Okay, thank you.
Any other questions for staff?
Can you get the helicopter back? or-
Yeah. We can add that as a condition of approval, yes.
Okay, then I will go ahead now and open it up to the applicant for any comments.
I'm Craig Leone, owner of Chosen Motors. I do not live in the city. I don't know if I have to say that or not, but happy to be a part of the city. We are a small, debt-free Christian car lot. That is our whole thing. This is not my day job. I do this because I love it. We do it simply as my wife thinks I'm insane because I'm a car nut. And so this was a way that we could do something that we thought was useful or beneficial. Our goal is to simply move an existing small business that I do on a very, 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 very part-time down the street to a spot where it'll be a little more conducive to allow Six Star to use the space for their new advertising campaign and whatnot. And we can be down the street in our own space, which would probably fit us a little bit better too. So I don't know if there's any specific questions about the use or whatnot. We don't sell very many cars at a time. So for us to have 12 cars would be really awesome, but has really never happened. We are grateful that cars seem to sell fairly quickly, and we usually have somewhere between none and maybe 6 or 7, and we have ample parking in that gravel section where they will be somewhat visible, but really most of the car sales that we do are vehicles that people are contacting me from a posting on Facebook when it's first being made available, and those people are pursuing us at that point and hopefully buying the car even before it gets to the lot or about the time it gets there. But that is pretty well the highlights and the lowlights of what we do.
Any questions from the commission? I have one just on signage. Are you going to have signage there?
We have to have signage in order to sustain our state obligation. And our goal is to simply have that. I think it's approximately 4 by 8 is the signage required by the state. And we're simply going to apply that directly painted on the building itself. There was actually a previous slide where I think a previous realtor had simply painted their name on the building, and we did get permission from the owner to do that same thing.
Okay, any questions? Okay, then I will go ahead and open up the public hearing to public comment.
Time for me
Thank
to
you.
sit down.
Yes, you can.
Thank you.
Okay, now I will open up to public comment, and I will first call on those who wish to testify in support of this application, then those who are neutral, and finally those who are opposed. Again, if you wish to testify, particularly on testimony that would not repeat comments already made, please complete a sign-up sheet and hand it to staff. Please indicate on the form whether you are in favor, neutral, or opposed. Is there anybody here that's supports this project? Anybody that's neutral? Anybody that's opposed?
Mr. Commissioner, we don't currently have anyone signed up on Zoom or in person
Okay.
to testify.
Okay. So having no comments, then I guess unless the commission has any comments before I close the public hearing? Okay, I will go ahead and close the public hearing and we'll open it up for deliberations. Any comments from commission?
I move to accept the CUP with the conditions provided.
I would second that.
Okay, we've got a motion on the table for,
A motion to recommend to city council.
Yes.
yes.
No, I'm sorry, the planning commission takes final action.
Yeah, on this one here.
Sorry,
I was gonna say.
written in the script otherwise, my
Yeah.
apologies. Commissioner Benner,
Aye.
Commissioner Weber,
Yes.
Commissioner Mitchell,
Yes.
Commissioner Ramar.
Yes.
Mr. Chair, motion passes.
Okay, thank you very much. Okay, and we'll go on to the Next item on the agenda. Wait.
Oh, are you gonna,
I'm waiting for,
I think it's okay.
oh, go ahead. You can move, you can move ahead.
okay.
Chairman.
Okay. The next item on the agenda is the hearing and recommendation to amend Sandpoint City Code Title III, Chapter 12, short-term rental of dwelling units. And again, if you wish to testify, please complete a sign-up sheet and hand it to the clerk. Because this is not a quasi-judicial hearing, if there are members of the public on Zoom who wish to speak, we will take a remote testimony on this matter. We will begin with a staff presentation followed by commissioners' questions. Then we will open it up to the hearing from public testimony. After the public hearing has been closed, we will proceed with commission deliberation and a recommendation decision. I will now yield the floor to Community Planning and Development Director Jason Welker.
Thank you, Vice Chair. I'm going to share my screen. Okay. I'm going to do a little background, and then we're going to get into the amendment that's being proposed tonight. We're going to start with a question: why are we here? Took a few screenshots from some of the community response to tonight's meeting. I do want to start by saying that this is not something that staff was excited or enthusiastic about. Many of the other updates and code amendments that we're working on, we truly believe are to promote affordability in this community, to achieve the visions of our comprehensive plan adopted last year. As I indicated in my staff report, this amendment is not directly supported by a comprehensive plan in some regards, but in others it is, because a comprehensive plan does reference legally defensible management of short-term regulations. And we have, due to recent court cases in the state of Idaho, we have become aware that our current short-term rental ordinance is not legally defensible. So we are very aware of the community's response to this proposed amendment, and we're approaching it very seriously as a result. So that's the key point for this presentation, is that we need to understand the context in which this amendment is coming and the reason that we're here. And that it really comes down to, we are bringing our city ordinance into compliance with state law. So I'm going to talk a little bit about what state law says around short-term rental regulations. And this is the entirety in the right there of what our state law says around regulation of short-term rentals by cities and counties. It's very simple. Idaho Code 676539 prohibits municipalities from, and we have our attorney here, I'm sure he can weigh in on this as well if you have questions, prohibits municipalities from restricting, prohibiting, or regulating STRs in ways that have the effect of banning them, creating caps, limits, separation distances, or other tools that prevent a property owner from operating an STR. The statute is very clear. It allows for the regulation related to health, safety, and general welfare, and it does use language around protecting the integrity of residential neighborhoods in which short-term rentals or vacation rentals operate. So the amendment coming tonight, it's been described in the community as a deregulation, but I really want to emphasize that we are strengthening our regulation and at the same time bringing it into compliance with state law. That many of the changes do actually increase regulation of STRs, but it also proposes removing the cap that exists. And for the public, for commissioners who may not be aware, our existing ordinance, established in 2017, established a hard cap of 35 non-owner occupied short-term rentals in residential neighborhoods. So think about, that's a lot of words there. Non-owner occupied mean it's not the primary residence of the owner. That's established through the county's assessor's office, who records the owner exemptions. And residential means outside of the commercial zones and mixed use zones. So in the residential zones, which are RM and RS, does that include? No, that's it. Multifamily and single family zones, there is a hard cap of 35 units. That accounts for less than 1% of the housing stock in those zones. So what has changed in the last year that has brought us here today? Specifically, this court case. This was an Idaho Supreme Court case heard in January. The opinion was filed in May of 2025, and it related to the city of Lava Hot Springs, Idaho, who had their STR ordinance struck down by the Supreme Court, specifically because it established a ban on short-term rentals in residential zoning districts. Lava Hot Springs had been regulating STRs like businesses, and they were only allowed to operate in the commercial districts. Our STR ordinance goes almost to that extent by allowing only 1% of the units in our residential districts to be operated as STRs. Lava Hot Springs cap was at 0%, ours is at 1%. It's almost identical, but for we allow 35, they allowed 0. So the Supreme Court was decisive in this decision, and Lava Hot Springs ordinance and their cap in particular was struck down by the Supreme Court. Now, a couple months later, there was a district court case involving the city of McCall, Idaho, another resort community where STRs make up a much larger percentage of the housing stock than they do here in Sandpoint. And McCall's ordinance, which did not include a ban or a cap, was upheld. So in modeling our amendments to our code, we actually looked closely at McCall's code and said, well, what are they doing that the district court upheld that we aren't doing, that we could implement locally to possibly strengthen our ordinance? And some of the changes we've brought to our code are actually modeled after what was upheld by the district court in McCall. Now, I will say that ruling by the district court has been challenged, and that is scheduled to go to the Supreme Court in the near future. So we may see McCall's ordinance challenge, or we are going to see McCall's ordinance challenged at the Supreme Court sometime later this year. Over the summer, the community might have seen some headlines in the paper, or maybe even participated in a meeting in this room of the Affordable Housing Committee, chaired by Senator Woodward and Senator Redmond out of Coeur d'Alene. That group came to Sandpoint. It was a traveling roadshow. They did several meetings around the state. There was a half-day meeting here in council chambers at which many local and state groups came and presented to that Affordable Housing Committee, one of which was a representative from Airbnb. And that team from Airbnb came all the way to Idaho to basically put cities on notice and say, we are going after short-term rental regulations. Following that meeting, to that presentation to the Affordable Housing Committee, that group actually held a private meeting in which they invited Airbnb hosts from around the area. That meeting was not open to the public. It was not open to the press. But we understand the purpose of that meeting have been to recruit a plaintiff for a lawsuit against the city of Sandpoint. Our ordinance is extremely vulnerable because of our hard cap. What we've done in this case is removed the cap, but done everything we think we can do within the law to maintain relatively strict regulation of short-term rentals, specifically for the preservation and to protect the integrity of residential neighborhoods and to protect the health and welfare of the communities, which are things that are allowed under state law. So this is what our current ordinance does. What we're proposing to do, let me slow down a little bit. This is the heart of why we're here, right? We fully understand that our cap is illegal, and if challenged, a district court would just look to the ruling over Lava Hot Springs and determine that our cap is similar in its restriction placed on private property.
Jason, can I ask you,
Sure.
sorry, Jared?
Go ahead.
Our cap doesn't include developments that are over 8 or 10 doors or something like that, right? So, I mean, we're more than 10%. I mean, we're more than 1% of residences in the city.
The cap is on non-owner occupied, so we don't have any limit on the number of owner occupied short-term rentals. So there's certainly more than 35 short-term rentals in Sandpoint. As far as registered short-term rentals, we have around 200 that have licenses with the city. Around 170 of those, give or take 160, are owner occupied. So owner occupied would mean, maybe you have a condo and you rent your house out on weekends, or you have a ADU in the backyard, an accessory dwelling unit, or you have an apartment above your garage that you rent out, or just a spare room that you rent out. We don't limit those. We view that as a wonderful way for homeowners to make a little extra income on the side, and not without necessarily affecting the integrity of neighborhoods or the local long-term rental housing market. So is that what you're referring to, or?
Yeah, I'm just wondering where the 1% refers to the 35 cap.
Yeah, the 30, we have around 3,500 residential units in our RM and RS zones.
Right,
So
but-
that 35 represents 1% of the available housing stock in our RM and RS zones.
Right, versus 200 permits,
Right,
quite a bit more percentage wise.
sure. There
Okay.
are and then there are unpermitted STRs, which we're constantly trying to determine who those are, where they are, so that we can issue violation letters to those.
Right, okay. Thank you.
Okay, so, this is something that we are reluctantly doing, are amending this code. I think we understand that the community desires to see local control over the regulation of short-term rentals. But I did want to point out for the commissioners here, excuse me one moment, that this is a state law issue, and that community concerns over this should be directed to our state legislators. And I will say we are on year 3 now of an ongoing lobbying effort by the Airbnb funded group, Idaho Association of Vacation Rental Association, to lobby state legislators to further strip cities of the ability to regulate short-term rentals. So that language around health, safety, welfare, and the integrity of residential neighborhoods. The goal of this lobby group is to take those rights to regulate away from cities, eliminate the city's ability to track short-term rentals via permits or licenses, and finally, ultimately, to take cities' ability to collect short-term rental lodging taxes away. So about half of our city's short-term rental lodging tax revenue, 40% actually last year, came from short-term rentals. The other 50-60% comes from local hotels and motels. So that's an important funding source. As you know, we have a 14% local option tax on lodging that applies to all short-term rentals in Sandpoint. The ultimate goal of this lobby group is for short-term rentals to be treated like any other residential use. No additional taxes, no additional regulations, no requirements around fire extinguishers or CO2 detectors or ingress or egress or off-street parking. They want them to be treated just like a residence that somebody lives in year-round. So that is where the community's efforts should be directed if we want to restore and establish greater local control over the short-term rental market. This is coming back this year, full steam ahead. The Airbnb funded group has put more than $1 million towards lobbying in Boise to try to shrink local authority even further. The last attempt at this was a bill that died in commission last legislative session, but we expect the same bill to come back this year. Okay, now to our amendments today. This is about more than just eliminating an unlawful cap. We have completely rewritten the purpose statement of this code to bring it into alignment, basically word for word with what our state code allows cities to do, and then reviewed the entire ordinance to make sure that we are doing what's allowed under state law. So removing the numerical cap is part of that. Bill, our master code writer here, reshuffled and reorganized the subheadings in this chapter to make it a lot easier to follow and interpret and understand and enforce. So we've reorganized and modernized the structure of Title III, Chapter 12. We've also created a new category of STR permits called a high occupancy permit. We'll have a slide on that in just a moment. And the introduction of a conditional use permit for high occupancy STRs is another new addition. This is something that has been utilized in 1 or 2 other Idaho cities that regulate STRs. We've, for the first time, added off-street parking requirements in addition to the requirements for the primary residence. If there is an ADU, for example, being operated as an STR, or an apartment within a house being operated as an STR, those will have their own off-street parking requirements. We've added that local representatives must reside within 20 vehicular miles. This is for non-owner occupied STRs. If there's an out-of-state owner, they have to have a local representative who is ready to respond 24 hours a day to any complaint from a neighbor. And to streamline administration, we're moving from a rolling application where you can submit your application any time of the year, and it's good for 1 year, to renewal annually at the beginning of the year. So if you apply in April, for example, your fee for your permit will be prorated for 7 or 8 months, and then you'll have to reapply on January 1st for the new year. This is to kind of take some of the burden off of our administrative staff. Mandy Brown here, our administrative assistant, is basically our point person for STR permits in the city, and she could probably tell you it's hours and hours a week as permit applications come in or being renewed or being expired, or we're sending violation notifications. We want to streamline that by bringing it from January 1st to December 31st window, where a permit, similar as we do to business permits in Sandpoint. So I mentioned the high occupancy STR permit type. This is an addition. This is something that is done in one or two other Idaho cities. For those STRs that are really operating like an actual bed and breakfast or a small, hotel of sorts, we're going to require a conditional use permit. That's a permit that is approved by this body. It will allow for the addition of certain conditions tailored to site context and to preserving neighborhood integrity and character, such as parking, screening, noise mitigation. These permits will require public notice and hearing, and compatibility with the underlying zoning district and the comprehensive plan will have to be found in order to approve these. So this is one way we are increasing regulation of STRs. We are distinguishing between standard short-term rentals and high intensity or high occupancy short-term rentals.
Jason, just before you,
Yeah, go ahead.
how was the 12 determined? Was that,
That was modeled after another Idaho city that uses that cutoff. Also, just kind of the number of bedrooms. If you think about, how many, what's the experience? If you have a 3-bedroom house, it's not unreasonable to think 10 people might be able to stay there. That's a lot of people in a 3-bedroom house. If you have a 4-bedroom house with a fold-out bed, you could easily fit 10 people in an Airbnb like that. But when you get to, more intensive uses, or we've all probably crashed in places where we've brought our inflatable mattresses. If you're advertising your Airbnb for larger events or parties or gatherings, that's a high occupancy STR. Those are likely to come along with greater neighborhood impacts, and therefore certain restrictions should be, or the commission should have the right to, impose additional conditions on those. So high occupancy, there's another city that uses that number, and internally we discussed that as sort of a point at which you're really moving into kind of a new realm of experience and impact on the neighborhood.
it can't be 4, 3 or 4?
Do you want to hear 250 conditional use permits per year? We'd be in here 5 nights a week if we were processing CUPs for every short-term rental in town. 5 nights a week. It would be a full-time job for you all. So the local representative, not much changed here other than we added the 20 miles, the 20-mile radius language. That's used in many other cities as well, just to make sure that there is truly a local representative. So you're not saying, oh, I can be the local representative. I live in Boise. That's not what we're looking for here. The expectation is you have a local property manager that can respond to complaints from neighbors if there are complaints from neighbors. That local representative's contact information must be posted inside the door of all short-term rentals as well. That's currently in our code. That will remain in our code so that renters know who to call if there's an issue. Or, an additional thing that's in our code and will remain in our code is the requirement that all STR applicants have to send written notice to neighbors within 200 feet of the property with information about who to contact in case of complaints. So that's already in our ordinance. That remains in there as well, just to give neighbors notice that there's an STR in your neighborhood. If there's something going on there, you don't have to call the police necessarily. You're welcome to, but you can call this number and the local representative is expected to respond. And there are infractions in our code. I'll get to that in a minute. This is new. We didn't have an off-street parking requirement for short-term rentals before. These are not allowed to be street parking, of course, and they are in addition to parking requirements for any existing residences on the property. High occupancy STRs, that's going to be a condition that the Planning Commission can settle on when it comes to the conditions of approval of a CUP. Okay, we do have enforcements and violations in our code that do result in permit revocation. So protecting this, again, under state law, protecting the character and residential character of neighborhoods is allowed. So repeat violations will result in permit revocation. And this is a complaint-based system. Of course, neighbors are, if we hear complaints about STRs in neighborhoods, that this is our mechanism for revoking those permits. Illegal operation, that refers to advertising STRs that are unlicensed. We assume in our code already that if an STR is being advertised on Airbnb, Vrbo, or some other website, and it's not permitted, that's an infraction. So you will be immediately notified, and whatever the fine is in our fee schedule, currently it's $110 per day for a violation of operating an STR without a permit. Once a permit has been revoked, there's a 2-year prohibition on reapplying. This is all to point to the fact that we have quite a lot of regulation of STRs in Sandpoint, and we are strengthening those in our current amendment. Okay, what our amendments do not do, we're not increasing the allowed occupancy, we're not reducing safety standards, we're not reducing enforcement, we're not reducing the options for the city for permitting or licensing Airbnbs and short-term rentals. We are actually increasing our parking requirement or adding parking requirements, and we are improving and streamlining our licensing and permitting procedures. Okay, just to remind you, this is what we're allowed to do under state law. We're allowed to regulate health, safety, occupancy, parking, things like solid waste, noise, nuisances, things that affect quality of life and the experience of the residential character of neighborhoods, local contact representatives, and then building and fire code compliance. That's the life safety things. Okay, so I also wanted to, just before the meeting, I added this line here. If we recommend amendment, and this is a recommendation to council, if we recommend amendment as proposed today, Sandpoint's STR ordinance will remain the most restrictive in the state of Idaho. Ours is currently the most restrictive, but also unlawful. We're bringing it into compliance with state law, and we will remain the standard bearer and the model for other cities as far as how to regulate STRs for the benefit of residential character of our neighborhoods. If we keep the cap and we risk litigation, and given the Supreme Court ruling in Lava Hot Springs, and I invite you to ask questions of our legal counsel here, we believe that we will lose a legal challenge and possibly risk the entire STR code being struck down because it brings it into the under the microscope in the case of any legal challenge. So these are your your options for action tonight. Pretty standard. And that's the end of my presentation. I invite any questions that you have before you open the public hearing.
Chairman? Yeah, go ahead. Yes, I do have a couple questions. First off, who will enforce it? I mean, are we going to appoint somebody in the city staff to enforce it? It sounds like it could be a pretty good a job. I mean, it would.
This is already a job. I would estimate that between Mandy and our assistant planner, Katie, this is around 20% of their positions is administering these, our existing short-term rental program. As far as enforcement, as we do with code compliance issues across the city, we bring in our community resource officers to deliver violation letters. They're given usually 10 days to come into compliance. If you're operating an STR without a permit, for example, our letter says you have 10 days to apply for a permit. After that, the fines start racking up, the $110 per day fine for violations. Okay. So that's all done in collaboration with the police department and the planning department.
Okay, now per property, I was reviewing, just quickly, I reviewed the Ketchum, Idaho short-term rental plan. And then I also did review the 67, 65, 39. And I remember one mentioning, I don't know whether is, if you could have more than one Verbo or Airbnb on a piece of property, is it limited to one?
It is.
Like, so if you're using your house, a room in your house, but you do have an additional dwelling unit in the back, you can't use that as an Airbnb also. You only one or the other.
Correct. Now that's true in residential zones, not in commercial zones. In commercial zones, you can operate as many units as you want on one parcel.
Okay, and we're talking about this. Is this ordinance strictly for the RM and R?
Our STR ordinance applies. The rules laid out here are citywide, but it distinguishes in the rules between residential zones and commercial zones.
Okay, and commercial zones, would these be allowed in commercial zones?
Would what be allowed?
Airbnbs.
Multiple. Oh, yes, of course, yeah.
Okay.
Well, sure. I mean, commercial zones are for businesses. A position one could take is that operating an Airbnb is akin to operating a business. Mm-hmm. So there hasn't been in our code any attempt to take away a property owner's right to operate a business in a zone designated for operating a business. The idea is a business compatible with residential zones. That's where our cap was. That was the theory behind establishing a cap, was that businesses should not be operated in residential zones. Okay. But in a commercial zone, there's no limit on how many Airbnbs can be operated.
Okay, so now parking, you're saying that, besides let's say we have a 3-bedroom house and they want to rent out, they have an additional dwelling in the back, they want to take it out. So the 3 parking places that the people have in front of their house, let's say 2 in front of the garage or 3 in front of the garage, they could not be considered parking for the Airbnb in the back of the house. That was off the alley.
Not if those parking spaces are required within our code based on the size and number of bedrooms in that house.
And we have an existing code that does do that.
Yes.
Okay. And yeah, and I see, and you brought up much of it. It says that reasonable regulation is allowed. This is in the 67, 65, 39. Local governments may adopt reasonable regulations to safeguard public health, safety, general welfare, and the biggie, integrity of residential neighborhoods. I know the city of Sandpoint is reluctant to involve itself in lawsuits. I understand, it was explained to me by the mayor, the insurance issues about it. But at the same time, it looks like you're trying to give us the most you can. But at the same time, are we that terrified of litigation that we aren't willing to walk a little bit into the gray on this thing or not?
In regards to maintaining a hard cap of.
Well, not a hard cap. A hard cap we know isn't going to work. I mean, that's just flat against the law. But I mean, I'm just saying, as I saw, in Ketchum, they go through a whole bunch of stuff like you brought before, that there has to be a fire safety inspection in the house, and the fire alarms have to work, et cetera, et cetera. Also a tax, and you're saying the taxes would remain at 14%?
So yeah, I didn't present everything that's in our existing ordinance. I kind of focused on the changes. We already require all those
So
inspections.
the 14th, so that wouldn't change.
We have the highest lodging tax in the state of Idaho in Sandpoint already. So we already tax short-term rentals and hotels at a higher rate than any other city in the state, and that is 14%. So again, going back to, we currently have and we will continue to have the strictest STR regulations and highest tax rate in the state of Idaho after this amendment.
Okay, and then how will this affect P and Z for future applications? I mean, I know we're working, and where are we standing on the parking downtown? You know, the units being built on Church that didn't
Yeah,
have
good
that.
question. There's the parking ordinance is already, that's gone through city council. We've restored off-street parking requirements for residential downtown 3 or 4 months ago.
Okay, that's very good. And yeah, when I was writing, is that the our offside street parking during the winter, especially on the south end of town and actually through most of the environs. I'm just trying to figure out how the parking's going to work. You know, in other words, if you can only park on one side of the street, it seems to me that there'd be a lack of parking in the residential neighborhoods, you know, should these Airbnbs, because I mean, like you said, I mean, they can turn into party
Yeah,
homes.
and in fact, it was McCall's McCall's STR ordinance that we studied in preparation for our amendment here. And it was their off-street parking requirements. And in fact, in McCall, what they found was that many of their winter lodging guests are pulling snowmobile trailers, for example. And they found that snowmobile trailers parking on the streets were creating nightmares for plow crews in McCall. So they implemented off-street parking requirements specifically in response to that issue around snow plowing. And we have this similar issue here, not so much with the snowmobile trailers, but with the plowing challenges and the burden that, you know, having 200 STRs in town with potentially 400 to 500 additional cars on the streets causes is a justification for why we added parking requirements. So that is a good reason why we added parking requirements here, because we don't want to inconvenience our residents and our street plow crews that might face, you know, during the ski season, there might be 100 people staying at Airbnbs in town or more, bringing 200 additional cars in town. They need to be able to park off street. So that's a requirement under the new code.
Okay, and then the last thing, which is really not that important, but you were mentioning that this group, you know, looking to find people that they can go ahead and file lawsuits for supporting Airbnbs, you know, without any restrictions whatsoever. Also, I don't know if you noticed on your first lawsuit, the plaintiff was,
The Idaho Association of Realtors.
yeah.
Correct. Yep. Big money.
That's all I have. Thank you. Okay, go ahead.
Yeah, sorry. My questions are mostly for Zach. Sorry, Zach Jones, attorney. So how do you define, so like I read that decision in Lava Hot Springs versus whatever, IAR, which I have to be a member of. So, not all big money. So how do you define the line between regulation and prohibition? Because that opinion is only like 2 pages, and it doesn't seem like there's a test in there that like helps the court figure out the difference between regulation and prohibition.
Sure. So I guess just a quick point of clarity, there were also individual plaintiffs
Right.
in that lawsuit. So it was the Idaho Realty Association and individual plaintiffs. That's neither here nor there. With respect to your question, the Supreme Court actually defined that. And the way they defined it as is, let's see if I can get it right here. Regulations are distinct from prohibitions. To prohibit is to forbid, prevent, preclude, or severely hinder. To regulate is to control, especially through implementation of rules. So
Yeah, but
that's
feel like-
absolutely nebulous. And the Supreme Court even said, we're not going to take it further than this. So later on down the road, the question is going to be what is severely hindering short-term rentals. But the Supreme Court also said in their decision where they were analyzing the legislative intent that the plain language of the statute we take the legislator at its word to expressly disallow any city regulation that has the express or practical effect of prohibiting short-term rentals in the city. And so, I think clearly the 35 units disallows and practically prohibits short-term rentals within the city. And so that one in and of itself is a prohibition because it prohibits anything more than 35 units within the city. And I think that would be a hard one to defend. With respect to your question, specifically when regulations cross the line into prohibitions, that's a fact-specific question. We are of the opinion, the hope that the regulations that we are presenting to the commission tonight will not cross that line. But of course, we'll have to cross that bridge when we come to it.
Yeah, that's kind of my real question is like, are the occupancy limits of 12 people or whatever, you're having to have a CUP for 12 people or more, parking requirements, 20 vehicular miles for a property manager, are those tantamount to a prohibition? Like a regulation crossing over into prohibition?
So I would submit that no, they're not. Take the property owner, for example. If you're an out-of-state property owner, you're not prohibited from renting your unit as a short-term rental. You just need to hire a property manager. And that's just part of business. And so that's not a prohibition by any stretch of the imagination. Parking could be a little bit fuzzier depending on the specific facts. But again, as Mr. Welker was saying, there are legitimate reasons, using the snowplow example, why to enforce parking. And there are lots of options with off-street parking as well. And so I don't think that crosses the line for a prohibition either. And then the occupancy, again, the higher the use, the more impact it's going to have on residential neighborhoods. And so I think the more authority the city's going to have to regulate that based on 67, 65, 39.
Okay. And I do have one more question for you. Like, so there's a question of per property, one STR per property. What about properties that are one legal parcel that are multiple unit condos like Westwood or Condo del Sol? How do we deal with that?
So are you okay? So it's getting into the weeds a little bit with respect to how we're actually going to apply the new ordinance, but first and foremost, anything that's not in the residential zone, the one resident per property isn't going to impact that. And then with respect to anything that is in the residential zone, the intent is to preserve the character of the residential neighborhood. And so I think that by having one resident per property, it is going to preserve the character of the neighborhood. And I think that is defensible based on, again, the code section.
Is it defensible with ADUs?
So ADUs are typically going to be,
like
if a non-owner occupied tries to have an ADU, that's a good question. And again, I would probably say that depends on the individual circumstances.
Okay, and one last question. Sorry, I keep answering it. Can HOAs limit this independently?
No.
No. So HOAs can override.
That law changed off the top of my head maybe 4 or 5 years ago. And so new HOAs can't really enact anything limiting short-term rentals, and previous HOAs can't really enforce them. So I guess mostly no is maybe more.
So if I'm a owner of a unit at Schweitzer And our HOA has a no short-term rentals less than 90 days. That's basically, I mean, those are
Unenforceable.
unenforceable now. And the same for every HOA in the state.
Yes, I am going from the top of my head on that question,
Okay.
but I'm fairly confident that that's the answer.
Okay. Thank you.
Okay, Mr. Vice Chair, I have
Yeah.
a question.
Read.
This is also for Zach. And so hypothetically, if, potentially you table a decision, don't act at all tonight, and then we just wait and see, and, there's a case with McCall in the coming months that's going to be litigated, or it's going to the court system. And so, like, what are the risks to the city of Sandpoint if we just sit back and see how that plays out and what might happen in that meantime? And, is there financial risk? Can this decision be addressed in the future when there is an immediate, danger, immediate presence of something in the future?
So the answer is that ball is in your court, and actually to go off of something Commissioner Ramar said earlier, are we so afraid of litigation that we're not gonna, we're gonna just change our ordinance? What we're trying to do is just present a defensible ordinance to you, and when you evaluate the risks, that's really your decision, and frankly, city council's decision in evaluating the risks. The risk is that our STR ordinance will be found unlawful, that a lawsuit is initiated against us. The city has to spend the cost and resources of defending that lawsuit. Who knows what that looks like, frankly. Lawsuits are Pandora's box. I mean, you open them and you just don't know where they're going to go and how they're going to end up. But at the end of the day, in May, the Supreme Court unanimously rendered a decision indicating that prohibitions on short-term rentals based on the existing ordinance, or sorry, the existing statute is unlawful. And it's my opinion that, at least with respect to the 35 unit cap, that's a prohibition for anybody else trying to get there. So we have an unlawful ordinance, and it is our job to have our ordinances be as lawful and defensible as possible.
Prohibition, collective or individual?
That's a good question. I'm going to say, based on the facts in the lava, I mean, if I were in a position where I had to defend this lawsuit, I'd be making different arguments. I would say it's collective. And the reason is because if you look at the Lava Hot Springs lawsuit, they try to talk about how bed and breakfasts are allowed and how it's allowed in commercial areas, and they use the disjunctive that's in the statute for the or that's mentioned several times in the statute, and the Supreme Court really wasn't hearing any of it. They were looking at the legislative intent. And I guess one other point of clarity, there are 3 other code sections that are applicable here. It's called the Short-Term Rentals Act. It's 63, 1801, 1802, and 1803. All it does is it provides definitions, and then provides the legislative intent. And I think what the Supreme Court was really deciding on was that the legislative intent was to allow for the free use of short-term rentals.
Another question. So within that Idaho State Code 676539, there's the reference to the integrity of neighborhoods and just basically adopting reasonable regulations to safeguard the integrity of residential neighborhoods. And so do you have a definition of the integrity of a neighborhood, or is that something we can easily define?
That would be the plain language. I mean, that I'm fairly certain is not defined in the Short-Term Rentals Act. And so that would just be your dictionary definition of integrity of a neighborhood. So no, it's not easy to define.
Yeah.
In a nutshell, I think the real question isn't going to be whether or not something we're trying to do is protecting the integrity of the neighborhood. I think that will probably be accepted. I think that the question will be, is what we're trying to do amounting to a severely hindering or prohibiting the short-term rental?
Okay.
Any other questions from the commission for the staff? Yes, sir.
Yeah, one more. And this comes underneath I downloaded the thing, they had the key provisions of the code 67-6539. And the other one was, I forgot to mention before, zoning classification. It says STRs and vacation rentals are legally considered a residential land use. They must comply with zoning requirements applicable to residential properties. Did you guys look into that when you were putting this together?
Yeah, that was kind of at the core of what we were considering.
So you're getting my feeling here. At least I don't know how anybody else feels. I got a real good idea how these people feel. But I'm just asking you in a bunch of different ways of how can we legally be as restrictive as possible without inviting a big dog lawsuit. And that's why I'm bringing that up. And then marketplace operations. Cities and counties cannot regulate the operation of STR marketplaces such as Airbnb and Vrbo. I think I think you've done a great job with what we have so far. Since we have various options here, what to look at, do you personally feel, I mean, I'm hoping that 2 weeks or to a month isn't going to make a big difference. Do you feel that with additional time and after listening to the input from the citizens that we could maybe tighten this up a little bit, or you think you've just about taken it everywhere you can?
I think it'd be good to hear from the public first.
Well, that's it. Thank you very much.
So I have one more question. So like, I mean, speaking of what Commissioner Romar said, like the must comply with zoning requirements applicable to residential properties. So like, can we impose more parking restrictions on STRs than we do on single-family residences?
I mean, I think the answer to that is yes, based on the language in 6739,
Okay.
6539, that we're allowed to create regulations specific to short-term rentals.
Okay. So what if we jack those up?
Just to clarify, you said more than we impose on single-family residences. So what if we said in our code, a minimum of 10 off-street parking spaces must be required per bedroom for short-term rentals?
Yeah, something like that.
Does that act as a prohibition on short-term rentals?
Probably.
Yeah.
It would.
Yeah,
But we've reflected the parking requirements in our residential code with regards to short-term rentals. And in some circumstances, that's going to increase the burden on the property owner because they may have a spare room, and our code now says you need to require 2 off-street parking spaces for that Airbnb.
Yeah, I mean, I guess that's what my initial question was, is like, what burden can you place on them that's legal?
A reasonable burden.
Yeah, but what's reasonable?
I mean, this is why lawyers exist. I mean, we're not going to have an answer for you. You're asking great questions, but there's not going to be an answer for you on, I mean, that's going to be a very fact-specific question that occurs when a lawsuit happens.
Yeah.
I think as a result of that, there'd be an awful lot of garages that are currently stuffed with, kayaks and mountain bikes are going to be emptied out to have to accommodate the 2 off-street parking requirements in addition to the 2 additional for the SDR. So people's garages are also going to be filled with cars now so that the 2 spaces in front of them can be used for the STR. So that's going to be the effect of that.
And another question is, in review of an STR permit, our planning staff will review the application to assure that adequate off-street parking is required, and if not, that permit will be denied. And they will be forced to either comply with the off-street parking requirement or withdraw their application. So we're saying, like, what are reasonable regulations that can, allow us to protect integrity of residential neighborhoods? This is we believe, a totally justifiable, reasonable regulation.
Yeah, I'm just wondering, like, with Commissioner Romar, like, how close can you go to unreasonable or illegal while also deflecting the chances of being sued by my association?
So my answer to that is we've kind of racked our heads together a fair bit to come up with what we've come up with. We're all ears, both with you and the public. If you come up with good ideas, we can table this and come back to you.
Yeah, no.
Any further questions? Okay, well then I guess we'll go ahead and have the public hearing. And the rules previously stated for public testimony are still in effect. And Madam Clerk, has anyone signed up to speak, or are there any hands raised on Zoom?
Yes, we currently have quite a few in person um, signed up. So starting with Eric Engling.
Good evening. Good evening. State my name for the record, and I live in city of Sandpoint the last 5 years. Thanks for that to staff for that presentation and those important questions. So first of all, some interesting questions were raised, and I looked it up just on the fly, thanks to our friends, our AI friends. Um, and so right now, there's been about 11 lawsuits nationwide where Airbnb sued or filed suit against the city. Just to be clear, they didn't win every time. In fact, they lost 4 times, most notably San Francisco, Santa Monica, Boston, and New York. Okay. So I do understand the desire to avoid litigation. However, it doesn't mean we're going to lose. So there is precedent for cities standing up for themselves. And I think to what some of you were alluding to, I think one could argue that part of preserving the integrity of our town is in fact limiting the amount of Airbnbs and the way in which they roll out in our community. I think you could very much argue that. So what I would say is, tonight's proposal to deregulate short-term rentals, I don't think it's a harmless housekeeping change. In my mind, it's a direct transfer of wealth and stability away from the people who live and work in Sandpoint and into the pockets of Wall Street traders, Silicon Valley tech bros, and out-of-state investors who already have more than enough. So every town that's opened this door has watched homes stop being places where families live and become financial products traded by people who will never set foot here. So, I mean, ultimately, when you strip away the talking points of, threats and litigation, this proposal is going to do one thing in my mind. It makes it easier and more profitable for investors to buy up our housing stock. Okay? So once they own it, it's gone. Year-round rentals vanish, prices climb, neighborhoods hollow out. And the people who keep this town running get pushed out, while investors collect revenue on homes they treat like ATM machines. Okay, and so, yeah, we're being told this is necessary to avoid a hypothetical lawsuit. But changing our entire housing policy out of fear of litigation is not leadership, it's surrender. Okay? So if a lawsuit ever comes, you fight it in court because litigation keeps the current protections in place. Deregulation, which this is, I think, destroys those protections immediately. And once a home is turned into a short-term rental portfolio asset, it does not come back. In my mind, Sandpoint's current ordinance is a fair compromise. It allows short-term rentals, but it protects year-round housing and the character of our neighborhoods. Keeping it is not just the legally cautious choice, it is the more morally responsible one. And so I urge you to take no action or to postpone it, reject deregulation, and stand with the people who actually call this place home, okay? And I'll conclude by saying that, believe it or not, I think land court can be your friend. Litigation often pauses change, whereas deregulation kind of unleashes it, right? We all know the free market moves faster than the wheels of justice, right? I mean, I was a city councilor back east. Land court can go on for 3, 4, 5 years, okay? And so, anyway, those are my points. Appreciate your time and consideration.
Thank you.
Next, we have Mary Wilkos.
Good evening, and thank you for the opportunity to comment. I've been a city homeowner since 2006 in a neighborhood that I love. In 2020, I built a one-bedroom ADU as a guest house on my city lot and hosted hundreds of guests year-round via Airbnb and VRBO platforms. I enjoyed hosting the visitors from around the country and other countries and relied on the short-term rental income in addition to other income sources. Last year, I moved to another home in Sandpoint and subsequently discovered that the rules had changed and I had lost the ability to continue to rent the ADU guest house as a short-term rental because I no longer lived on the property. I rent the main home as a long-term rental, and the property is maintained in excellent condition, and I still have excellent relationships with the residents of my old neighborhood. I support a change in policies that supports owner flexibility to own and operate a property as a short or long-term rental while protecting community values and neighborhood integrity. I support the new requirement for a 20-mile radius for the owner. I do not support the requirement for 2 off-street parking spaces. That doesn't make any sense to me based on my experience. My one-bedroom ADU was built in 2020 in full compliance with city code at the time, including off-street parking requirements. My multi-year experience managing that one-bedroom ADU is that my guests arrived in one car nearly 100% of the time. My winter guests have been mostly skiers. I have never hosted winter guests with trailers. Meanwhile, homeowners and long-term rentals in my neighborhood frequently have multiple vehicles parked in the old neighborhood, and my new one actually, frequently have multiple vehicles parked on the street and sometimes in their yards, which is an eyesore. Parking requirements need to be reasonable and equitable for all city residents. Parking requirements should not discriminate against vacation rentals. This is not fair or reasonable. Thank you for the opportunity to comment tonight. I hope I've presented another side to this situation.
Thank you, Mayor.
Next, we have Kevin. I'm so sorry.
No one can pronounce you.
Good evening, Commissioners. My name is Kevin Klunder. I am a CPA here in Sandpoint. I'm a City of Sandpoint resident since 2002 and a small business owner downtown. I come here to thank you for taking on this difficult topic. No one's going to be happy with your decision, but I don't think you have any choice to make a decision. I think they've presented that Idaho law has changed and that, well, Airbnb has lost some cases in other states. Those are not Idaho cases. We're in Idaho. We have to rely on Idaho law. What I've come here tonight to ask you is that we make a few considerations on this. Primarily, it's on the line between high occupancy and low occupancy. An occupancy of 12 would destroy the character of our neighborhoods. City of Sandpoint occupancy on houses, according to the Census Bureau, is 2.3 residents per house. So to go from 2.3 average occupancy to 12 would completely destroy the character of a neighborhood. You're going to have a lot more cars, you're going to have a lot more traffic, a lot more people in and out, a lot more conflicts due to that increased density. And as they pointed out earlier to you, there's going to be a line. If you have 12, you're probably going to see very few conditional use permits that you have to come for you. But if we have 2, we would have a lot. I'd ask you to try and move that to 4 or perhaps 6. Or maybe we look at it on a per bedroom basis, that we have 2 people per bedroom as occupancies. Anything more than that requires a conditional use permit, because that would generally bring the occupancy in line with our current residential uses of the homes now, if we have to expand this. And as far as parking, I think we could be a little bit flexible and require 1 parking space per bedroom, with maybe 1 extra. That would bring us in line with something that's useful. We have a 5-bedroom home, we're going to require 5 parking spaces, maybe 6. But if we have a 1-bedroom home, we only require 1 or 2 parking spaces. That's probably what we're going to see in line with seeing people coming to Sandpoint to use those on those ADUs. When I've traveled, I've used these. It's wonderful. It's nicer than a hotel room, which would be the other point that I'd come here to bring you. When we expand these, we're not going to see a giant impact, because if we get saturated with a whole bunch of short-term rentals, prices are going to go down. So it should be somewhat self-balancing with the economics of it. But the other thing that I would encourage the city to be looking at is these are a replacement for hotel rooms. Sandpoint has not built any new hotel rooms within the city of Sandpoint in decades. Averill may change that, but we need to get some more hotel rooms so that we reduce the demand for short-term rentals within the city of Sandpoint. Thank you very much for your time this evening.
Okay, thank you, Kevin.
Next, we have Terry Pardini.
Good evening. My name's Terry Pardini. I am a city resident. I've lived here since 1979. First of all, it's interesting that it's already in the ordinance or whatever, the STRs, that if there's one in your neighborhood, they're supposed to give letters to the people in the neighborhood. Well, there was one in my neighborhood. Never got a letter. I just saw the sign out front. So that nobody's really regulating, apparently, but maybe we can change that. I'd kind of disagree with the definition of prohibition. You're probably too young to know this. I wasn't around at the time either, but there was prohibition at one time in this country, and they didn't allow you to have 35 bars in your town or 35 drinks. You were prohibited from having any. However, restricted, if they had restrictions on you, you could have bars, not during prohibition. So I'm just saying the law says you cannot prohibit, which is basically banning any. It doesn't mean you can't have some. So it appears that we are not in violation of the law by restricting the number of vacation rentals that we have. I also wonder how you can guarantee the integrity of a neighborhood if we absolutely have no restrictions on the number of short-term rentals. It seems impossible to me to even imagine. However, I love a lot of the amendments that you made, and I think that perhaps they could be applied without taking away our cap or a cap on the number. I think that many of the new amendments are great, and they should have been there, and I think that they will protect integrity of the neighborhoods. But I think that if you take away the cap, you are just really opening up the city, perhaps for other lawsuits, because people are going to be buying homes or already have homes in a neighborhood where now they can't even live there because it's so overrun by people who are only there for 1 or 2 nights and party all night. I have friends that live next door to one, and it's their biggest complaint is all the cars and the partying until all hours of the morning. So thank you for hearing me, and I hope you will really take this under advisement. Thank you.
Thank you, Derek.
Next, we have Torres Joshua.
Good evening, Commission. So I was just trying to understand, is there an option for us to do a moratorium on this particular situation from code 67-6523 and 67-6524 during that time that we have a chance to basically evaluate our current codes, and that gives us 6 to 12 months to evaluate those codes and establish whether or not we're going to be up to regulation, but that gives us time within the community to just to start figuring it out. And we're not jumping the gun on this. So I don't know if Zachary can speak to that.
No, we're not, there's no
Okay,
questions.
copy.
We just-
But yeah, that's just a suggestion. I mean, I really think we need to slow down this process, and I think this is a way to do it. Thank you.
Okay, thank you, Josh.
Next, I have Rebecca Holland, not a city resident.
Good evening. My name is Rebecca Holland. For the record, I am longtime resident, live out in the county. Have had a business in Sandpoint 30 years, but I'm retired now. My interest is in the future when I may be again a resident as I get older. I really think that I like what Commissioner Ivan was saying about being as restrictive as possible with allowing out-of-state people to come in and buy up our town. We know that's a problem. We know that we see that in other communities that have been fighting that, and it's, I know folks personally in Colorado that have been speaking to that as their towns are just overrun with that in Summit County. One of the questions I have, and I know you can't answer this, but to consider is the requirement be that you have to, all of these have to be local. Why can't it be just local people making it available in their space to have rentals, as opposed to making this something on the market for speculative buyers who are basically just playing a game of Monopoly? And we know the ramifications of what this is in terms of affordability for the community. And that's what, as you evaluate things, I'm sure you look at it as what's in the best interest of all the people that are here. And I hope you would consider that. And as we look at legal issues, and in particular, I know that, the state doesn't like the feds pushing on them. I don't know why the state thinks they can push on municipalities like they do. But that's the power struggles that you see. But by rolling over and giving it up, that's what you've done. And I would hope that Sandpoint, that has a good reputation for holding a position, that will do that. So thank you for the opportunity to speak. Thanks.
Thanks, Rebecca.
I have no further community members signed up to speak or give testimony.
Okay. So is there anybody in the audience that would like to speak and hasn't had an opportunity to speak? You need to fill out no.
Next up, we have Cassandra Morelli. Oh, you pronounced it right. Thank you.
Hi, I'm Cassandra Morelli. I live in the city of Sandpoint. I moved 5 times in 1 year based on the fact that there was Airbnbs all around me. There were like vacant neighborhoods. I didn't know my neighbors. I couldn't build community. For someone that's came from a big city to a small town, like, community is everything, especially here. And I'm having trouble getting behind this. Like, we need caps on Airbnb and vacation rentals. Short-term rentals need strict local regulations in small towns. Without caps, zoning limits, and enforcement, they distort the housing market and accelerate displacement while offering little lasting benefit to the community. Our community is beautiful. We help each other out. And we're there for each other. Like, anything you need, ask your neighbor. But if your neighbor doesn't live there because they've been pushed out by like big businesses and private condo owners and townhomes and whatever, but they're not letting you rent the space because they have private investors or, like, people with a lot of money coming in from out of town, then it ruins the locality, the integrity of our town. And I think that's not okay. Also, I just moved into a place, hopefully it's the last one for a long time, but just next door, they put in 3 ADUs in the back alleyway of their house. And from what I understand, I mean, that's not legal. Or that's a problem because there's no parking. It's like 2-bedroom condos right next door. It's going to cause a lot of noise and a lot of irritation for our neighborhood. And I'm not going to be able to get to know my neighbors because they're going to be gone in a week. So that's what I have a problem with. Thank you for taking that into consideration.
Okay, thank you. Anybody else? Last chance. Okay, seeing no hands raised or anybody, we will now close the public hearing and go ahead and deliberate. So any questions for staff or Commissioner Remark?
Yeah, I do have some questions for staff. After I'm listening to some of the public input, there were some key notes. I'm curious could you have different restrictions on the Airbnb occupancies in residential areas as opposed to commercial areas? I.e., if they're in a commercial area, you can have 12. I'm just saying a number. If you're in residential, you're limited to 6.
Correct me if I'm wrong, but the 12 owner occupancy specific, that's just for the residential neighborhoods. So there's no restriction in commercial.
Okay, well,
neighborhoods.
maybe put a restriction on the residential and leave the commercial wide open,
Well,
i.e.
I
what I'm
think
trying to
that's
see,
what there
create is
is.
a pathway where somebody getting involved with Airbnb, especially if a REIT comes in and wants to develop an Airbnb complex, that we make it easier for them to do it in a commercial area as opposed for them to try to buy up, numerous homes in the south side of Sandpoint and all of a sudden say this, we want to do it here. See what I'm saying?
I think I'm following it, but to be clear, the restriction is in the residential area. And so,
Actually, our current draft of code doesn't distinguish between residential and commercial for high occupancy STRs. Just keep in mind that there's not many single-family homes in commercial neighborhoods, hardly any at all in the entire city of Sandpoint. So those are generally going to be apartment buildings that are in commercial neighborhoods, for example, or homes that were there before it was zoned commercial that might be operated as STRs. I can think of a couple of those in Sandpoint.
Okay, the other one was a moratorium. It's not a bad idea. I mean, I hadn't even thought about that. I mean, what would we would be leaving ourselves open to get our head chopped off?
So I'm not sure. So a moratorium under the local land use planning act, you need to declare that an emergency exists in order to have the moratorium. And I don't think that standard is going to be met here.
Picks and shovels and torches next week.
That's I wish that would be if that met the standard of an emergency, that would make my job a lot easier. But so I don't think that a moratorium is the appropriate, from a legal perspective, is the appropriate avenue to go here. But from a practical perspective, if you guys don't want to make this decision, you don't have to make this decision, or more pertinently, the city council doesn't have to make this decision. And so you can choose. I mean, you can't choose to not enforce your ordinance, but you can choose not to change this ordinance. And so I don't know what a moratorium from the perspective of the local land use planning act would accomplish, and I don't know if it's even appropriate.
Okay, and then the last one Rebecca brought up about the locally owned homes. I guess that would be kind of tough though, where you're saying that yes, you can have an Airbnb, but the home has to be owned locally.
Yeah, and that was the fact pattern in the Lava Hot Springs case.
Okay. Yeah, that's the only questions I have been asking.
Okay. Any questions for staff? No other questions of staff?
I make a motion, I'll make a motion, I don't have the right wording.
Yeah,
that-
so
You
just
put the motions back up.
very quickly before you make your motion. I mean, going back to the moratorium, I think I was a little thrown by the legal term of art that a moratorium is. I don't think that's exactly what you're trying to accomplish. I mean, you can recommend to the city council to postpone action until the Supreme Court makes a decision on this McCall case, for example, or until the the next legislative session ends to see if the legislature changes the statute at all. That you can do, certainly. So again, we're going to be in, yeah, I'll just leave it at that.
I mean, but could we change? So let's just say we accept it as it is tonight, or move it on to city council and they approve it. What would it take to amend it if after these court cases, we find that we have the ability to restrict them even more? Would it be a song and a dance, or would it be easy to do, or?
We'll be right back here. Same process.
Same process as this.
Same process.
I mean, speaking to the public's concern that, you know, that locality, that municipalities, cities should have, I mean, put us in perspective of the way that we function underneath the state Supreme Court as far as how our statutes have to follow the law.
Sure. So it was commented that states push back on the federal government, and that shouldn't the municipality push back on the state? So first and foremost, states are constitutionally recognized within the federal government, and that dichotomy and that distinction between the two, there's very clear delineations between those. Of course, you can get real fuzzy too, of course, there too, but the existence of municipalities are, for the most part, a creature of state law. And when it comes to specifically, so not necessarily constitutional law, when it comes to specifically the short-term residential or law, that is 100% a statutory question. So the Supreme Court's decision, there was no constitutional analysis in there. It was purely statutory interpretation. What does the state law say? So the state law could completely nullify and say absolutely no regulation on short-term rentals at all. And we'll be here trying to draft an ordinance that has no regulations on short-term rentals at all, because it is, at the end of the day, our obligation to follow state law.
Whereas California could make state laws that say you can have a cap of 10% or 1%.
Yes.
Okay.
Any other comments, questions? I guess,
Oh, I was just gonna make a motion.
I got a question. Bill,
Thank you, Chair. Just for the record, I want to make sure you're fully aware and understanding each of your options here, especially option 3, because that seems to be what our legal counsel is trying to articulate, that you do have an option to try to understand where the legislature or court cases may be headed. So just for the record, want to make sure you understand your options. That's all.
yeah, I was just going to ask about that for Zach on the, if we did that, are we still opening the door for a lawsuit if we are tabling our decision to wait until the legislature acts, or then we get the next court case resolved?
So from an academic standpoint, yes, because so long as this ordinance is in effect, we're obligated to stand by this ordinance, and a lawsuit could come into effect. From a practical standpoint, I mean, 2 weeks is a lawsuit going to be initiated in 2 weeks? Anybody that's watching these hearings, are they gonna wait until the next public planning and zoning meeting before they decide whether or not to initiate a lawsuit? Probably. So from a practical standpoint, how closely are we staring down the barrel of the litigation gun, so to speak? I don't think that a short time will increase the liability at all.
So in other words, we don't wait until the end of the next legislative session.
I mean, that's a slightly different conversation, because we're talking about a longer period of time with more potential for change and damages and so on and so forth.
At what level would the city lose this lawsuit? Like, it just in county court?
So the district court is the trial court,
sorry.
and that's the first level that this would be heard at. And then should it get appealed, it would go up to either the Court of Appeals or the Supreme Court, depending. It's actually the Supreme Court's decision on whether or not they hear it directly from the district court or the Court of Appeals. But all trial cases, barring very unusual circumstances, start in the district court.
And you think we would lose there?
No, I mean, do I think that this ordinance as it stands would survive a declaratory judgment action? Probably not. I see some serious problems with it.
Mr. Chairman,
Yes, go ahead.
can I make a motion now?
Go ahead.
Okay. I think I'd like to go with number 3, postpone for further review. Not so much to wait for any legal cases to do, but I'm thinking until maybe the next P and Z meeting or one meeting after that, just to let you all digest what you heard tonight and be honest with you, to let the citizens of Sandpoint realize that, we're going to go back and think on this, knowing that we have to meet the law. I mean, we have to, and litigation is not good for anybody. And I don't know if you're aware, but if in a conversation that I had with the mayor probably 2 months ago, he was explaining to me that, in various states other than Idaho, the cities combine in a large insurance policy. So should a city get involved in a lawsuit, it looks to that large policy to fund, my understanding, to fund its defense. That's not applicable in Idaho. So the city of Sandpoint would have to foot the bill for any defense should it go to litigation. But at the same time, I think you've heard from both the people and my concerns, and I think here is that aggressive would be a nice word to use. As an aggressive a posture as we can. So my motion is to just postpone for further review to the P and Z meeting on, what would that be, somewhere around the 18th of December or something?
Can I ask a question to you?
Sure.
Why not adopt these and then also add more later? If we want to add more aggressive language to this, oh, sorry. Why not adopt this now to eliminate the cap, eliminate that avenue for a lawsuit, and then if we want to adopt more aggressive, regulations, which I think we're, like thinking is a good idea, or like how do we, say yes now, get as close as we can to the line later, protect ourselves now, and then also armor ourselves later.
I'm just concerned that, we're talking a short period here, 2 weeks.
Yeah.
Yeah, or a month at the most. Is that, it's like a can of water, you spill it on the ground, you can't get all that water back into the can. I'm concerned that if we just say, okay, well, this is fine, and we'll review it and modify it as it proceeds, I think we'd be losing an opportunity here I'm not saying that the thing has to, as far as I'm concerned, change dramatically, because I think you understand that there isn't a whole lot of dramatic changes we can do with this by law, but there could be some nuance. And that's the reason I'm asking for a motion on postponement as opposed to accepting it now. Is there any other problems?
If I may, Vice Chair.
Yeah.
I will say that in preparation of this amendment, Bill and I investigated, researched, looked at every short-term rental ordinance in the state of Idaho that we could find. And like I said, we drew ideas from those. We believe this is the strongest in the state of Idaho because we've taken the strongest components of different cities and implemented into ours. So just wanted to remind you that this has been a multi-month effort. Not to say that, the postponing is absolutely a acceptable motion to make, but unless you have specific, changes you'd like us to further investigate over the next couple of weeks, I guess I'd like some specific suggestions that we can investigate over the next couple of weeks if you're going to postpone it.
Yeah, for example, since there is a pending motion on the floor, if part of that time to evaluate would be to look at the parking requirement, to think on that, to see if that was too restrictive or not, or the threshold for occupancy, what's considered a high occupancy versus a regular STR, if that number of 12, her testimony, her in commission speaking. So is that in line with the types of things you want us to think about over the next couple of weeks?
Yeah, sure.
Okay. We're trying to build a record here.
Anyway, that was my motion. Either vote on it or change it or vote.
Okay.
I'll second that.
Okay, it's been moved and seconded. Any further discussion on the motion?
Could we read back the motion as it stands?
So I have postponed for further review of occupancy and parking standards.
Specific. Oh, you asking me?
Yeah.
Oh,
you're the one.
I'm wearing my glasses. I can't see far away. Anyway, and as mentioned, yeah, the neighborhood integrity, which is a kind of an open thing, but we ought to consider it. Yes.
And that postponement's for 30 days or to our next meeting in December?
The second meeting in December.
Okay.
I believe, when, do you know when that would be, this second meeting in December?
Looks like it would be the 16th of December.
16th of December, that give you guys sufficient time? And I'm sure you've got lots of other things to do. Yeah, it sounds great. That's the motion.
Okay, and we have a,
Commissioner Weber?
Can I just say before voting, just to give me, I think the reason for my postponing or seconding this is to give me more time to consider the change to the code and the specifics within the code to parking standards, to the cap, increasing it from the smaller scale to larger scale. And I mean, hopefully this will be just a question for the staff, will be a closed public hearing at the following planning and zoning, or would that be open to the public again?
It'll be a new public
a
hearing.
new public hearing.
Okay.
Same format as tonight.
Okay. Well, I think, and then potentially give the public some time to mull this over and maybe come up with some creative solutions instead of just saying, no, we don't want this change. So that would be, I think, pooling the resources that we have as a community. There might be some opportunity in that time frame. And then, yeah, we can circle back and following public meeting. So that's all I have to say.
I think
You have to vote.
you need to vote.
You have to vote. And yes,
Yeah, okay. You're voting yes.
or sorry. Yes, to postpone. Yep.
Commissioner Mitchell?
No.
Commissioner Ramar?
Yes.
Commissioner Benner?
Yes.
Mr. Chair, motion passes.
Okay, thank you. Okay. Take a break for just a second, or just, no,
I'm good to go.
okay?
Ivan, do you need to take a break for a minute before the next meeting, the next business?
No, we're discussing
Lot coverage and stuff, so,
Oh, yeah, I think I will take, if you want.
okay. We'll take a short 5-minute break. Thank you. Okay, we're back in, it's 7:26. And we're on to old business, and it's the item to discuss lot coverage, lot size, and development standards in the RM and RS zones. And I will now yield the floor to City Planner Bill Dean.
Thank you, Chair. This is an agenda item that's really a discussion, again, before we bring you back a revised ordinance for your consideration. And I believe Jason has, do you have a PowerPoint on this one, Jason?
I have an update to our last
Yeah.
PowerPoint, which has now been updated twice.
So Jason and I have been tag teaming this back in our offices to try to arrive at really thinking about what the commission's been engaged with in terms of discussion on the size of the lot versus the amount of coverage you would be allowed to have. And so we put a lot of thought into that. Jason's going to walk us through an update on that. In the end, we also have a couple of additional things we're trying to sprinkle into the ordinance as it relates to addressing affordability, namely lot size and the amount of density you can have in any given lot. So tonight, Jason's going to walk us through a couple of those updates, and then the whole point is to continue this dialogue, try to have one more discussion before we bring back an ordinance at a hearing that you could forward to council.
Okay, thanks, Bill. And in fact, I think one thing you got wrong is I think we're actually going to start with the additional amendment we were
Let's do it.
peppering in. So we're going to get to our lot coverage, evolution of our lot coverage amendment in a moment. But first, I'm going to let Bill talk a little bit about an additional proposal that we're going to be bringing to the public hearing on December 2nd, which is scheduled 2 weeks from tonight.
So this entire conversation about lot dimensions and lot coverage it brings to the fore something that Jason and I have been talking about since the comp plan was adopted. The comp plan has got some great language in there regarding minimum lot size. It specifically states that in the residential single-family zone, 5,000 is a minimum. In the residential multifamily, however, they should be varied. And one thing that struck me ever since I've been here is just looking at the existing development pattern across the RM and RS zones. And it's clearly a situation where the existing development pattern does not match the zoning standards. Requiring a 5,000 square foot lot now, when a good portion of the built environment was originally platted at 25 or 37 and a half foot wide lots of 3,500 square feet, it seems to speak to something we should be discussing, whether or not this community can and should support going back to a smaller lot size in the RM zone as opposed to having it be the same as the RS zone. So what we're wanting to discuss this evening is proposal to reduce that minimum from 5,000 to 3,500 square feet. It's more typical of the existing substandard lots of record. The original plat at 25 by 140 or so feet gives you about a 3,500 square foot lot. That's how historically Sandpoint was platted. A good amount of the area in the RM zone has that development pattern. It's just our zoning doesn't allow it today. But I think our comp plan provides us some guidance in suggesting that maybe we should have some variety to these lot sizes to accommodate additional density in this part of the city. We're either going to achieve affordability through density or we're going to achieve it through subsidies. That's typically the two big levers that you have. And since affordability is something that's constantly being talked about, we're exploring ways to loosen up some of the standards and modify the standards such that we can begin to address affordability from the side of production of housing and a modest increase in the amount of doorknobs per lot. And one way to achieve that also is through looking at the lot size itself. So, Jason, you want to add to that?
Yeah, just, you can zoom in on like 80% of our residential neighborhoods in Sandpoint, and you'll see hundreds of yellow boxes that are illegal. They're non-conforming. These were platted 100 years ago, and subdivisions like this are no longer allowed to be platted in Sandpoint. So in a way, we're going back to the traditional plat of Sandpoint. We're allowing new subdivision to reflect the historic character and intent of Sandpoint's original subdivisions. And you think about who platted Sandpoint originally. These were the mill owners in town that needed housing for their workers. These were the forestry operators who needed housing for the loggers and the railroad employees. Sandpoint's original subdivisions were platted for local workers. Later on in the mid-20th century, development patterns changed, and the preference was for larger lots and more green space surrounding lots. Well, here we are today, struggling to find places for local workers to live. We just heard and I'm really saddened that everybody left after the previous hearing, because this is a really important conversation for our community to have around affordability as well. So that's really what we're trying to get at here, promoting a style of future development that fulfills the vision of the original development that took place in Sandpoint, which is to provide affordable places for people who work in local industries to live. In summary. Yeah, but we have a lot more to our presentation, but before I move on, go ahead.
No, real quick, just a question. It was the setbacks from I'm not supposed to do that. The setbacks from the side. So if you had a lot 37 feet wide by 100 feet deep, so if you're going 5 feet and 5 feet on either side.
Thanks for bringing this up.
Yeah, you'd be at 27 feet and a width on the building, which is a reasonable width. And with the 15 in the back and the 20 in the front, you could build to a depth of 65 feet, which, it turns out to be a 1,700 square foot building on a single story. So that's pretty good sized building. But my concern is we're not looking to shorten the setbacks to 0, are we?
No, correct. And in fact, in the proposed amendment, which I'm not going to show you tonight, it's going to come in 2 weeks, is, just because I don't have it on a slide in front of me, is to articulate, make it clear that any lots narrower than 37.5 feet will be subject to the development standards in our, and this is a real mouthful, Bill, it's our development standards for traditional substandard lots of, original substandard lots of record. Okay, so we have a whole section of our code called development standards for original substandard lots of record.
Well, let's just think about that for a second. We have a zoning ordinance that has an RM and an RS zone. And in these zone districts, there's a whole section dedicated to the reality that a huge portion of Sandpoint was platted with smaller lots than we currently want, which is 5,000. So when we're struggling with affordability issues, we're seeing more cottage development applications come in. We're seeing requests from property owners to ask us what it takes to get one more doorknob on a lot. Immediately, the first thing that came to me a year ago when I read the ordinance is why do we have the same standard for the RM as we do for the RS when the development pattern itself is a small lot, small house development pattern? So what we're trying to do is arrive at what would be a reasonable return to that pattern and asking ourselves, is it reasonable? Of course, setbacks would have to work, lot coverage, those types of things. But that's really what the question is here is this a reasonable thing? I have to come here and think about what the policy structure is that we just adopted. And that's what the policy structure is to try to promote ways to address affordability. And this is certainly one way to do that. So by no means is this a fait accompli. We have to have hearings at this before commission and council. But tonight's purpose was to just, begin to socialize this with you and say, is this in the realm of something that makes some sense or just jettison the idea altogether?
What does the substandard rule say?
Smaller setbacks.
Yeah.
What are they?
3 feet.
3 feet. So on a 25-foot lot, it's, you have 19 feet.
Yep.
Okay.
And there is development like that in Sandpoint because these lots do exist and you are allowed to develop on them. They just cannot be created anymore.
Right.
New subdivisions are not allowed under current code to reflect this historic development pattern.
So as happened years ago, and I suggest if we were to have something like this again, you begin to see an interesting pattern where, property owners may be able to work with one another to adjust lots. And okay, you've got maybe you got 3 of these things together and you split them and now you have 2 property owners that may have a 30 or 40-foot wide lot each, something like that. Still adding density where today it wouldn't be allowed.
Another really interesting effect that we will allow, or something that will be affected by this amendment if it advances, is that we do currently allow 3,500 square foot lots in our RM zone for attached townhomes. Yeah. But there's a huge catch. The minimum frontage is 37.5 feet. So you're forced to create a shallow lot if you want to provide attached housing, and then you're forced to have 37.5 foot wide housing units that are attached to each other. It's a very unusual townhome style.
And it's incongruous with the development street and alley pattern of a good portion of the city where you have deep lots. So it creates this situation where townhomes are just more difficult to develop.
We've seen almost none of them because that rule just doesn't really make sense for townhome development. This will allow for attached townhome development on narrow lots.
With the 3 foot, if you reduce it to 3 foot on 25-foot lots, you can. I mean, there's no reason why you can't. It's getting a little close. Reminds me of Balboa Island. But my concerns are you wouldn't be able to put any mechanical inside that 3 foot. That's too small to put you can throw a HVAC, condensing unit in there, but I mean, it's going to be a noise problem to your neighbor, especially if it's right next to their bedroom window.
Yeah, undoubtedly. No, absolutely. When you're talking about a lot of this size and setbacks like that, these are the types of character issues and that you have to be clear-eyed about.
Yeah,
I agree.
I mean, I think that would be something you'd have to put within the building department in some of the ordinance saying, and let them know that, okay, the mechanical has to be, on the long length of the lot, so behind the home or.
Right. That's a good point. Typically a setback is from the ground to the sky unobstructed. And there's usually carve outs with the exceptions for things like AC condensers and whatnot. I've recently drove around just looking to see how many AC condensers were on the sides of homes. I think all of them were. I mean, it's very, very common. Yeah. But that's a good point, something to think about.
And then the other thing is, yeah, are you counting the overhangs? So, I mean, you can build a house in a New England style where there essentially is no overhang. And like you said, it would be sky above, but if you allow 24-inch overhangs or 18-inch overhangs, then you're reducing that 6 foot total between the two by 36 inches. So, all of a sudden there's only 3 foot for snow to fall off the roof, land on a fence and not create some problems. So, the tiny lots are doable. I mean, they're right across the streets over here. They're some of the first ones that were ever done did it, and it's doable. It's not always attractive, but it's doable. My 2 cents.
What's the setback on the alley?
Depends on what you're putting back there. It's
Like
anywhere between
a garage
1
and ADU.
15 feet.
Yeah, between 1 and 15 feet, depending on what's
A
going on.
garage ADU is 1 foot,
Detached garage.
detached garage,
Yeah,
yeah,
yeah, sorry, that's what I meant.
yeah.
And most
Um,
of the, I don't know, to stay on this topic a little longer, but most of the RM zone does have alley access, right? Is that how
Most
how
of
it's
it,
laid
yeah.
out? I think that's kind of key in having these smaller lots. Having that alley access is going to be really important.
Yeah, I think that's exactly what struck me, Commissioner, when I was looking at this. Just what is the existing pattern? Number one is, zoning was a relative new invention compared to the life of some of the data, the original approval of some of these plats. So what, what could match what's there?
Mhm.
And I think you're spot on the idea, the fact that the alleys enable, a lot pattern like that.
Any other feedback or comments on this proposal before we bring it back in 2 weeks? Are we generally supportive of this idea?
Yeah.
Yes.
Okay. I'm going to go on to the revisit the now for the third time our discussion around impervious surface standards. So just for just very quick recap, we currently have 2 standards. We have a max building footprint standard and then an additional impervious surface maximum on top of that building footprint. We're basically telling homeowners and property owners that you can cover up 70 or 65% of your lot with impervious surface, but we're only going to allow half of that to be living space. The other half, feel free to pave over it. So the idea behind this proposed amendment was let property owners do what they want with their property, and if they want to provide additional living space for, let's say you have a aging parent who you want to do an addition on the back of your house, who is the city to say you're allowed to pave it, but you can't put a bedroom back there? So that was kind of the guiding principle here. Again, more living space per square foot in Sandpoint. Infill density. This is going to be what ultimately promotes affordability in this town. So we proposed a very simple amendment that just said eliminate the max building footprint standard and go to a single impervious surface standard, which is 70% on both RM and RS lots. The feedback we got from the commission was, well, we're worried once you get up to those 8 to 10 to 15,000 square foot lots, what's going to stop people from building a 10,000 square foot house on a 15,000 square foot lot? I guess that'd be a 14,000 square foot lot, and just max out their impervious surface standard with the McMansion concern. So you all proposed, what if we reduce the percentage as lot size increases? So we came back with what I'm now describing as a wide step decreasing max percentage as lot size increases proposal. That's option 2. We're going to look at how all these sort of look in a minute. The feedback then came back, well, what about the cliffs where somebody on a 7,000 square foot lot can build up to a larger max impervious than somebody on an 8,000 square foot lot because their percentage decreases when they go up to 8,000 square feet. So we narrowed the steps, and we now have an option where every 1,000 square feet the percentage decreases. He's not here tonight, but our favorite engineer on the Planning Commission, Commissioner Torpy, sent some follow-up emails, and that line wasn't smooth enough. So we've also provided now what I'm calling the smooth curve decreasing max percentage model. So we're going to look at those 4 options here, just review what they look like in a table form and how they might be described in code. So this was option 1. This is what we brought to you about 6 weeks ago. Just go to a simple 70% of your property can be developed with impervious surfaces. You'll recall that for the smaller lots, 5,000 square feet and smaller especially, this is an absolutely non-binding limit. It does not affect it. Setbacks consume more than 30% of the lot on the smallest lots in Sandpoint. So we're really talking about lots as you go from 5,000 square feet up. Obviously, the setbacks become less and less binding. They consume a smaller and smaller percentage of the property. So when you get to the larger lots, you do expose yourself to the potential that some property owners might choose to consume 70% of the property with a building, with a roof over it. Of course, you also have to take into account driveways, parking spaces, patios, everything else that might be impervious under this approach. So on the left here, some kind of summaries here. Easiest to understand and administer, very easy for staff and for the community to understand what this standard means. Is it the fairest? Everyone gets to utilize the same percentage of their property. So we're not taking any property rights away, let's say, for owners of larger properties. We're not saying, oh, we're telling you you can't develop more than, 70% or more than 30% of your property or whatever it is. This is what we brought a few weeks ago, what I'm calling the wide step model. This is one where for larger lots, and in this case, when you get above 7,500 square feet, we start reducing the max impervious percentage as you approach the largest kind of, lots that would conceivably have a single home on them in Sandpoint. Generally, you're going to see more, 12,500 square feet is a pretty large lot. That's almost a third of an acre. You don't see a whole lot of single family lots or in the RM zone with single houses on larger than a third of an acre. But that would decrease and approach our rural residential max impervious, which is 35%, I believe, 35%. So the idea here is get closer to what we require in the more rural parts of town, which there's only one rural residential neighborhood currently in Sandpoint. That's the Goodman neighborhood west of the railroad tracks in North Sandpoint. Commissioner Reimer.
Yeah, quick question. So let's say, well, I actually do. I own a lot with a wetland. And so my property line is out in the middle of the wetland. So my home's already built and everything. But let's say I was just building on it now. Could I, so the lot size would be, let's just say it's 7,500. So maximum impervious area is 60%. Can I utilize that portion of the property that's in the wetland as part of the non-impervious area?
You get the appropriate permits. This isn't this.
I mean, I'm just saying.
This is agnostic to the character of the property.
Okay.
This is just there may be other limitations. Every property may have its own unique limitation. It could be an easement that somebody owns, for example. This is just a straight, this is how much hard surface can go on a lot, regardless of its condition. You may have a lot that it's not going to enable you to be able to do that because you've got an easement, you've got a wetland, you've got a,
I think what Commissioner Romar is saying is that some lots have a very large square footage because they extend into waterway
Right.
or into a wetland, and that might be a third of the lot, right? Can you cover up the other 60% because that third exists even though it's unbuildable per?
And my answer is yes. This is agnostic to the characteristics of the lot.
Okay, yeah.
The problem the commission identified with this approach was these cliffs that it creates. You can see a real numerical example there. An 8,000 square foot lot, the owner would be allowed to develop only 4,800 square feet of that property versus a smaller lot would be allowed to develop a larger percentage of their property and an actual larger square footage. This model is also still relatively easy to administer. So we worked on it a little bit following last meeting. We came up with some narrow steps. What if you go down to 1,000 square foot bands? And we just, okay, we're going to step it down in smaller increments. This still creates cliffs. On the margins, you're still going to create cliffs here because we're not using a formula to calculate percentage. We're just saying, we're going to get down to 40% for those larger lots, but we're going to do it in narrower bands. This was kind of where we left off last time. And then Commissioner Torpy challenged us to come up with an even better solution. So this is what let me go back. Still relatively easy to administer. You're just creating a table that staff has to reference a table, right? No calculations needed.
I would argue that it's going to be hard to explain to Mrs. Jones why 66%, why 69%, why 61%. If I can't answer that question, that's trouble.
Yeah.
Right.
The latest version of this and the most refined is what I'm calling the smooth curve or marginal impervious surface standard. This is similar, as was discussed last time, to our federal tax code. If you want to make something easy to understand, look at the federal tax code and apply it locally. People will love you. Fortunately, you don't have to file a return every year, but in this case, we just apply the reducing max impervious percentage to the additional land beyond that in a band that exists. So this is going back to like a 2,500 square foot band, but that reducing percentage only applies to additional property. So you get literally a smooth curve. This is just creating a graph of what the max impervious surface against the lot size would look like, and it's a smooth curve. You have to calculate the formula in Excel spreadsheet. Planners and the community can plug in their lot size. It'll tell them exactly how much, down to the exact square foot. So this is possibly the fairest of the three if smaller max size is desired for larger lots. But again, if your idea of fairness is treat everybody the same, everybody gets the same percentage, this is also a decrease in the max impervious percentage as lot size increases. This is probably the most difficult to administer because it requires a lot of explanation to the community, requires a formula. We're going to have some sort of calculator that we use every time a new building permit application comes in. So those are kind of the four. And here's an example. I actually created the formula in Excel and plugged in a bunch of random lot sizes here going up in size. You got huge lots at the bottom there, 50,000 square feet. That's more than an acre. But this does show how the percentage will just continue to decrease as lot size increases. We could create a floor if we said, beyond 15,000 square feet, it no longer decreases below 40%. But for typical lot sizes, these are some actual impervious surface amounts that would be allowed with that kind of smooth curve. So Bill and I debated, we want to just make a recommendation here, and we said, yes, we do just want to make a recommendation. And we conclude with our recommendation, which is to keep it simple and go back to where we started 6 weeks ago. That's what we recommend. We think it's fairest. We think it's easiest to administer. It's easy for the community to understand. The fear of the commission of, the McMansion model, I don't know. We're open for discussion again, but I can't think of any other ways to approach this than the four that you've been provided here. So we do want to bring something to our public hearing in 2 weeks that we think we have support for. So we're open to feedback now.
How often is the McMansion ever going to happen?
Often, I think.
Hmm?
So I think it's going to happen pretty often. I mean, you're going to look at maxing out your lot coverage as a developer or a homeowner wants to do its spec. I mean, there's examples of this in Sandpoint where people are maximizing what they can build in the last 5 years.
The question is how often they can do that on a 12,000 square foot lot or on a 15,000 square foot lot. And what share of that 70% are they going to choose to build structure on versus put patio on or put, parking on? Because those are the other impervious.
So with the curve, so you just find the meeting of the X and Y, right? And along the line or along the curve. That seems pretty easy to understand. For Mrs. Jones or whatever.
Well, just imagine that table in our zoning code and then people looking at it and saying, so how much can I do? Because it is literally the same as our federal tax brackets.
It would require a calculator because these lots are going to be down to the 6,732 square feet.
0.6.
Right, 0.6. And so you need a calculator for that. And no one on city staff's going to be able to explain, the calculus, because that's what it is, for that.
But I mean, in a way, it's the simplest because you go, okay, I got 5,000 square feet, draw it up. Oh, it's right there, 3,000, it's 3,400 square feet. I mean,
I think
give or take.
I'm going to encourage the commission to get back to what's the purpose
Intent,
of these rules to begin with. Mm-hmm. And it was interesting what Commissioner Member Weber said that, there's a concern that somebody might take advantage of the max. So we've had an interesting conversation this evening on another item about property rights and things like that. I'm trying to understand, I think that's coming from the perspective of being mindful of neighborhood preservation in terms of the look and feel of the neighborhood so that they, still have, tomorrow they have some semblance of what they look like today in terms of the size of these structures across the neighborhoods. Is that really what the concern is? It's not so much that somebody gets to maximize their property rights, or is it that you want to make sure that the rules still reflect a reasonable character issue? Is that, I need you to help me understand what you're saying.
And I think it kind of gets back to the original or the current language in our lot coverage, which describes, well, I have to look at it again, but I think something along the lines, like you have this backyard space, your neighbors aren't building up surrounding you in a kind of canyon of housing in your backyard. You're able to enjoy a garden back there without a 35-foot tall building projecting through 70% of your lot, and just leaving the back 25% open. And so I think there's this is the concern of, those who would want to maximize a 70% lot coverage that allows a building footprint, they would build up to that point, and they probably, if especially an alley accessed property, you're 1 foot off the alley, so you build an ADU, that's 1 foot off the alley, so you don't have any driveway back there, and then that 800 square feet or whatever the driveway would be in the front of the yard goes into your property square, the home square footage. It's just that much larger in bulk and mass. It's just a drastic jump from 35%, which is what we, of course we have today for the actual building itself. And they could pave the backyard, they could do whatever they want to make it impervious, but that's at grade, it's not 35 feet in the air. That's, I think, the big difference here that I'm still kind of struggling with the 70%.
I'm looking at the curve, the bell curve chart. And I mean, we're not talking about it. Well, we were, but I guess we're not talking about adopting it. But yeah, it seems wrong in that when you get to band number 6, 15,000 square feet, 15% of this portion. I mean, so that's saying that 2,000 square feet is all you could do for impervious area on 15,000 square feet is
on the last 25. Oh, you're saying beyond that. So
yeah.
So in that case, if you had a 20,000 square foot lot, approximately half an acre, you would be able to build or hard surface 15% of the last 5,000 square feet of that lot, right? But there's those brackets leading up to the 15,000 where, you have to add that to what you were allowed to hard surface for the first 5,000 square feet.
Oh,
Add to
those
that what you're allowed to
70%
hard
of
surface
this
for the next 2,500 square feet.
70%
Add to
of the
that what you're allowed to hard
5,000.
surface. Yeah, so it's cumulative. You keep adding it up to the margin.
Yeah, that's not
For
gonna
that
work.
reason.
Just like the highest marginal tax rate in the US is whatever, 60%.
Yeah.
But if you're making $1 million, you're not paying $600,000 in taxes. You're paying 60% on the last $500,000 that you earned or whatever it is. It's not that high.
For these reasons, I think it's just too complicated to put in the zoning ordinance. It's just not something that's going to be understandable.
And you think that small steps, it's too many steps? I mean, it's a lot of steps.
Yeah, I think our recommendation is to go with what we originally started with, which, by the way, is already intercoded in the mixed use residential zone. It's a single standard of 70%. The MUR zone doesn't distinguish between the two. It just says 70% lot coverage. And that's in the mixed use residential zone, which is technically under the commercial zoning districts, but it's already there. I mean, that's one standard. It's already on the books, and it's spread throughout the community.
Mhm.
We're finding typos in our presentation as we present it. So thank you to the public for reviewing our presentation. Anyway, you don't have to make a choice tonight. We're just looking for feedback.
Yeah.
And there's
Any-
no
any
way to
questions?
simplify that curve to basically you plug in your lot coverage, what number, into a calculator. It can't just, I mean,
Oh, no,
maybe
that's
since
what it
I've been
is,
in
yeah.
calculus, but everybody since I've taken calculus classes, so what is that formula?
Oh, it's an awesome formula.
Yeah, you have it. I'm curious.
Yeah,
You pull it up.
It's got more
It is this formula.
letters than numbers in it, kind of formula. I mean, I can do addition and it's tricky partner subtraction, but I'm gonna have to leave this one to, the engineers to write the formula.
No. I have an uncle who's really good at math. So,
Yeah, your uncle's excellent at math.
I'll show it to you really quick. No, this is an old one. I don't have my Excel spreadsheet open anymore that had it. Sorry. But it is an Excel formula that, if such and such between this and this, multiply it by this plus this previous calculation,
Yeah. It gets to be complicated.
That's
I'm still trying to think of ways to arrive, and I'm gonna challenge Commissioner Weber to think about this between now and when we bring an ordinance back, or call us, if you have an epiphany, but so an additional way we may not be thinking about the character a lot different than 35% if it can be vertical. I completely understand what you're saying. We're coupling this with the idea that we're trying to provide some relief so that we can address the affordability crisis that we're confronting.
But I'd argue that in residential single family zoning, building a 3,000 or 2,000 square footprint house versus a 5,000 square footprint house is not going to change the affordability crisis in Sandpoint much.
I think that that's what's going to happen with this conversation, right? Is everybody's going to glom onto one example. That's what's going to happen. Because we can bring up another example. Mrs. Jones gets to do a kitchen remodel and add a bathroom so that they can have a third generation live with them. Same house. Now you're dealing with affordability. So, I'm not gonna sit here and try to understand who might live in that house, but we have very few tools at our disposal. And so if this had been figured out somewhere in our country, I think that we'd all be looking to that. So I think locally we just have to do our best to say, okay, what are reasonable ways to look at these issues? And there's so many examples of different lots in RS zone or RM zone for that matter. And you look at all of the standards, like I was saying last time, it's really hard to look at this in a vacuum. And that's exactly what we're doing right now. But do we want to get rid of the porch requirements? Do we want to get rid of the garage width standards? Which standards mean the most? And so one way I've looked at this is, as it relates to character of neighborhoods, put a lot of thought into this, is that as you walk and experience a street, pick a street and go walk and experience. I encourage you to do this. A couple different exercises you can do. One is there is a concept of the public realm as you experience it down the public right of way. You drive down the street, you walk down the sidewalk. There's a portion of that front of that house that really is kind of the public realm. It's seen. We have ordinances that speak to that. Garage can only be so big. Got to have a porch. You're allowed to come even closer if you have a porch because it's a written rule that tries to emulate what this place was built like 100 years ago. As you get farther back in your lot, the question should increase as a community as to how much regulation we should put on what happens the farther you go back in your lot. Because that's really a private realm compared to a public realm. It's one way to think about it, just experiencing the street, which is a way of experiencing and understanding the character of the neighborhood. So it's not an easy thing to arrive at because you're right, these things could be taller, but they're taller back there. So now you're talking about the enjoyment of one property owner's backyard as their pastoral enjoyment of their neighbor's open space. But the price tag for that is that neighbor doesn't get to put the ADU in, right? Lots of different ways to look at this, and we can all find one or two examples that kind of fit the thing you're thinking about. And that's why it's so important we take our time with this. And that's why Jason and I have not tried to rush you. This is our third or fourth time talking about this. But another exercise is to just quickly walk down a block. Just walk down and count the doorknobs, okay? And you're going to get a sense of what that looks like. Then walk down that block again and really look at how many doorknobs are there. And you'll be surprised. You're going to find a lot more doorknobs. So character density is a complicated thing for us to regulate, but something's not working for affordability in this community. So we have to turn the dial on something. Our comp plan says, maybe we should look at some of this stuff. So that's what we're doing. And there's no right answer to this. It's like, so these rules that we have today were not always in place. There's something preceded them. And there's something preceded those. What we do know, there's just voluminous evidence in the record that zoning has become a major problem as it relates to affordability in our country. And so we're not exempt from those problems. So This lot size thing is a really important thing for us to get our heads around in the lot dimensions and lot sizes and lot coverage as it relates to addressing affordability. We have to really be careful with these rules because of the unintended consequences. But
is it safe to say that to address affordability, multiple types of units on a single lot would, get at that as opposed to a larger single family?
well, single family zoning really is about single family homes. There are some provisions for other types of homes in single family zoning. The benefit you get with a lot coverage of 70%, the marginal benefit to a smaller lot is a lot greater than it is to the larger lot. This concern of the big McMansion is real. Where my mind goes is to the ability for a smaller lot to have this flexibility to have a different kind of house. It's a tough one.
Yeah, I agree. It makes a lot of sense for a smaller lot. To increase the density coverage, but I think there's also with those larger single family lots, 10,000 square foot lot or whatever, 8 to 10,000 square foot lot, which there's a decent amount of in Sandpoint. With the 70% change, would that ever be provided only for those lots that are actually creating additional units like an ADU or creating a duplex and not just one?
So that's creative. So the idea that that's very heavy regulation in terms of you're allowed to go bigger if. Is that kind of what you're saying?
Right.
Okay, well, let's
address
think on
the
that.
affordability.
But, yeah, but I mean, well, so what if you wanted to build if you have a remote job and you want to build a detached office?
Right.
I mean, I don't know. It seems like a hard thing there seems like a lot of things on the if side of the comma.
That's why having done this for a long time, usually what results in markets performing better is less rules than more. I think what's one thing we are lucky to have here is we have this awesome grid pattern, right? I mean, Sandpoint's got this amazing street grid pattern. So we have a built-in character right there that it's not going to change, right? And we have very few large parcels for large-scale development. So the character of Sandpoint from an urban form perspective is going to be really hard to change. It's really about the amount of development on any given lot. That's what what it actually looks like is going to be a character defining thing because our street pattern's established, right? And that's huge. I mean, not every city is like that. Some cities are half vacant, right? And you've got huge tracts of land to develop and they could turn into spaghetti walls of cul-de-sacs. We don't have that problem here to a certain extent.
How many, I mean, what size lot and how many are within the city are affected by this change? Do we know that?
What did your uncle say?
No, we have that in our PowerPoint from last time.
It was I can't remember, but
Yeah.
it wasn't like that. It was mostly those lots in the category of 5,000 or, up to 5,000 square feet. Is that right? Those see the biggest change.
You show the table of adding another unit, by the way, per.
That was last time.
We did, okay.
Yeah, we did that last time. Yeah, again, we don't have the best data on this, but we did do some estimations based on basically some interpolation from our existing GIS layers. So this is that data. It's shown here. So in our RS zones, this is approximate number of lots based on different lot sizes. So we have a lot of large lots, but most of those are larger than 12,500 square feet and just haven't been subdivided yet. These are some of these are look at the average lot size. The average lot size is nearly an acre, 35,500 square feet. That's telling you that includes some very large undeveloped tracts of land in town.
That's most of the 7,500.
Yeah.
That'll be affected.
Yeah.
Thanks for bringing that back.
But I mean, you're talking, if you're talking about like McMansions, it's really those lots in the 7,500 to 12,500 square foot range, which you're talking a total of around 120 property owners is what we're talking about who are affected by this. So what percentage of those would take advantage of this and build, 7,000 square foot footprint homes?
Or divide it off into a smaller lot and
They can go down to 5,000 square feet in the RS zone, and then
Or 3,500 coming soon.
And also, I mean, that's kind of what we'd like to see more of, right? Is if you have a 15,000 square foot lot and one family lives on it, how do you increase supply of housing? You build 3 houses on it by subdividing it or short platting it in that case.
Yeah, I mean, that's an interesting question. So what's the difference between one lot with a big house versus that same space being carved up into 3 lots with 3 houses on it in terms of character? There's a difference, clearly, but I mean, that's the question, right?
well, and here again, it depends on where it's at. Because
Right.
it could be in an area where you already have the smaller lots and the smaller homes, so.
Another thing that's interesting about looking at the lot pattern here and studying it a bit is that there's no congregation of 12,000 square foot lots in one like neck of the woods. You'll see here and then there and here and then there. I mean, predominantly, I guess, on average, you could say they're probably, on the south side versus the north side, but they're not, it's not like it's all in one area. It's not like there's one block that has all of these lots. They're sprinkled out. So I think I encourage you to think about this some more. And, I'd be happy to go drive around town and look at some examples and with anybody if they want to spend time doing that. I mean, this is the big issue, and we're trying to have our cake and eat it too by addressing character and preserving what's so special about this place, but also providing some relief so that some change can occur that's moving in the direction that our comp plan speaks to.
Thanks for taking the time to go through this process. I'm still waiting for the single family zone residents to come banging down the door and talk at one of these events, but
Well, I mean, I live in a single family house with a, almost 15,000 square foot lot, and I'm not gonna build a 12,000 square foot McMansion because it's cost prohibitive anyway. Like, I think a lot of people that own those are not the people who have the money to build these kind of houses. But I might build an ADU with this rule.
My guess is you aren't even approaching your 35%.
Right,
You could
exactly.
fit an ADU on that property right now.
Yeah.
The real, like, as Bill said, the real beneficiaries of this amendment are those who live on
Smaller
5,000
lots.
square foot lots,
Yeah, that's
7,000
right.
square foot lots where, you do want to build an ADU. We heard from a member of the public earlier tonight for whom an ADU formed an essential part of her income.
Yeah.
We know there are hundreds of households in Sandpoint that are prohibited from building ADUs under our current code right now because of the max building footprint, and they're already up against it. We know there are.
Right.
So our comp plan says, look for ways to encourage construction of ADUs. This is one of those ways.
Yeah, and I mean, I've been talking to a lot of people about if we were to be able to scoot down to 25, feet and build a 1 foot setback on an alley, that would make a huge difference for a lot of young people.
And again, that speaks to the issue I was mentioning. There's a different sentiment when it's on the back part of your lot.
Yeah.
A different community feeling than it is when it's on the front. That's probably why we don't allow ADUs in the front yard. Well, you could make a rule that says you could do them there. Now, I don't think there'd be a single person that wants that. That's what I'm talking about, though. Why was label it? Because that's like public realm. It's not public property, but it's a public realm. You experience it as a community together, right? But if you want us to put ADUs in the front yard, just let me know. We'll write up an ordinance for that.
On a corner lot, yes, let's. Hey, go up to Nelson, BC. I can hand things to the neighbor through the window.
yeah, who wants to?
Yeah.
They're better restaurants.
But yeah, I mean, there's no set, I mean, kids are.
So this is a reminder, this will come to a public hearing in 2 weeks. with everything, and we'll have to redo some of this presentation for the public that's there.
Is it 2 weeks or is it maybe? a
No,
little
it's
bit
2
later?
weeks. and It's December 2nd. We noticed.
December 2nd.
Energizer Bunny here.
We're plowing ahead.
Well, if you want to, my opinion, I think go back to the original layout, make it as simple as you possibly can for everybody that's coming in.
Keep it simple, stupid. It's, so we make things
That's
work.
my feelings anyway, is that if you're gonna go off of some curve, you're gonna hire somebody else to be doing the deciphering for you, so.
Got it. Thank you so much.
Thank you.
Okay, thank you. Okay, is there any other comments from this planning commission for discussion? Hearing none, then the meeting is adjourned at 13, I guess? Right.
Thank you, guys.
Thank you, staff. You guys did a good job. Nice presentation.